The Pennsylvania Association for Retarded Citizens, or PARC, is an organization that benefits all citizens with disabilities. The Commonwealth of Pennsylvania and PARC fought against each other in court to decide whether or not residents in the U.S. with mainly intellectual disabilities should have the right to due process in court and the right to free public education. Before 1971, any child who would prove they had not reached the mental age of 5 or the first grade was denied access to public education and being given a chance to show their capabilities. They also could not challenge the decision fairly because those citizens had no right to due process. This case is significant because it gave citizens with intellectual disabilities the right to due process and free public education, which created the basis for the Individuals with Disabilities Education Act, or IDEA, a direct result of PARC and many other groups advocating for disabled personage. We see these changes and how they impact today in IEPs, 504s, schools, homes, and many other places. This shows how our community is responsible for providing the necessary resources for all types of children, excluding no one. The 1960s was a time of big changes. Many riots and protests occurred, along with the civil rights movements that were in full swing. Dr. Martin Luther King Jr. gave his famous I Have a Dream speech on August 28, 1963.
About the true meaning of its creed, we hold these truths to be self-evident, that all men are created equal.
Later in the decade, Malcolm X, a prominent African-American Muslim minister and human rights activist, as well as MLK, were assassinated. Indigenous Americans continued to fight for their right to exist, and women and LGBT groups protested societal norms. All this push for change happened because people were fighting for what they believed in, for more equal rights, and they were protesting for social reform. Schools were segregated. Children who were of color could not go to the same school as white children, and intellectually disabled adolescents were denied the right to go to public school. Overall, the 60s were volatile because large changes were happening. Regarding PARC versus Pennsylvania, 14 families were involved in the court case. People have created stories about these families' experiences with sending their children to school. These struggles are reflected in literature in this example of a fictional story from 1971, which is about a boy named Bobby. His family submitted an application to go to public school for 3rd grade but got denied access and turned away by the teacher. The teacher's reply to their request was, Pennsylvania state law allows public schools to deny services to children who have not obtained a mental age of 5 years by the start of 1st grade or of the age of 8. This upset Bobby's family because it was unfair. They had not given him any tests or analyzed his capabilities of being taught and doing the work. So his family partnered with other families who had similar experiences and started the Pennsylvania Association for Retarded Citizens.
In this county, we have no special classes. No nursery schools, no community or child guidance centers to give our children what parents of every normal child take for granted.
Soon after, they sued the Commonwealth of Pennsylvania and brought the case to court in January of 1971, where they told their versions of what happened to them and how they were denied access to public school. Later in June, the trial began in the United States District Court for the Eastern District of Pennsylvania. Over the course of a year, the case was resolved. They filed the complaint in 1971, and in 1972, the case was settled with a consent decree. The 3 judges overseeing the trial were Thomas Ambrose Masterson, Raymond Broderick, and Circuit Judge Arlen Adams.
The statutes of the United States require that any assertion that a law of a state may be unconstitutional must be heard by 3 judges.
They concluded the case by ruling that the current law that restricts intellectually disabled kids ages 6 through 21 from education was unconstitutional. The court also heard from 4 experienced experts in the field of teaching children with intellectual and developmental disabilities. The experts focused on the label of mental retardation, reinforcing the meaning behind the word and stating that there is no such thing as an uneducable child. Doctors advised parents to send their children to mental institutions and asylums, which was a really hard decision for some families, and the asylums weren't usually beneficial to the individual.
Very little future for the children or for those who are in these institutions.
During the 1950s, society treated disabled children like they were another species, and was calling them things like unhuman and mentally subnormal. This is why many families were told to put their children away. This made it even harder to find an accessible learning environment for the child to attend because many teachers thought it wasn't worth the trouble of adapting to more complex teaching. After getting rejected from so many schools, some families sought out a new solution to educate their children as there weren't many options in the late 1960s. Consequently, people were starting to realize how unjust this was to all these families and children, so they started a group called the Pennsylvania Association for Retarded Citizens, which they nicknamed PARC. PARC was made to help all these children and to protest for the law to change. In 1972, the case came to a conclusion and the law changed. Many disabled children were now given the opportunities they and their families had always wanted. As a result, the number of students who were denied from public school fell after the 1970s, and more students were getting an education. The side effect of this was that disruption became more common in schools since many harsh restrictions were lifted. Eventually, IEPs and 504s were created to help intellectually and physically disabled students get their education presented to them in the most fair and least restrictive environment.
My child benefits from FAPE because if it weren't in place, he would definitely not be able to go to public school. As someone non-speaking who does not reach developmental milestones on schedule, he would have been excluded.
When qualified for a 504, a child can get a better seat in class, more time to work on a test, and the instructions written rather than spoken, or other accommodations that they may need. With an IEP, they can get a separate classroom to work on their assignments, specialized instructions, and the right services for them to thrive with education. This is why it is much better to be in school post-PARC rather than before.
An IEP means my child can go to school, and I can feel safe knowing that they're being cared for with the right supports, that the things they're working on in school are appropriate for their specific needs, that they're learning things that we all as a team agree they should be learning, and that their goals are going to be measured and they're going to be written in a way that is easy to track and for me to understand and for us to make adjustments as needed to make sure that we're always doing the most appropriate thing for my child.
Another resultant change after the case was that intellectually disabled children and their families now have the right to due process in court, which they did not prior. Having due process means that there is a format of the court process that is the same for both sides. For example, they both get opening and closing arguments and an equal opportunity to state their position, present evidence, interview witnesses, and other activities that occur in a court case. Before these changes, when families in PARC tried to get their kids into school and got turned away, they could not challenge the school's decision. The law at the time said that it was legal for the school to turn away the child without fair tests or looking into the child's capabilities. This is why having due process available to them made such a big difference. Due process is a right that all people should have access to. PARC and due process help intellectually disabled children in schools in many ways. For example, with the ability to go to school and walk around a campus, they get to experience what many kids get to, and it can aid in making them more socially accepted. These children get to make friends and meet more people because they now have the opportunity to go to school free of charge. Private schools and special education can be very expensive and limiting, and with many families not being able to afford them, it was not easily accessible. Now that public education is accessible to these children and their parents, it is one less thing for the family to have to worry about. Many of these new opportunities are because of the protests PARC made to fight and advocate the government's responsibility to care for these children. This case was similar to Brown versus Board of Education because they were both fighting for equal rights in education specific to the populations they were advocating for. These cases have set paths and been role models for many other groups to look to and gain knowledge out of. From 1960 to 2025, many projects have been started, protests have been led, and arguments have been settled about the people's rights and the responsibilities of our leaders. People are now taking action and finding solutions to build better, more inclusive communities that everyone feels comfortable in. Schools are being built and created specifically for children with intellectual and physical disabilities because they are now understanding the opportunities and accommodations that can be made to further these children's lives. Although no problems are fully resolved yet, many people are working hard to help address these situations. This is the story of how PARC used their knowledge and experience to emphasize these children's rights and the responsibilities of the community, to change the schooling system, and to create a more equal education for intellectually disabled children.